Hello, I'm Angela Princewell.
And I'm Shireen Appi.
And I'm Sunshia Itinius.
And guys, today we're going to be talking about supervised parenting. As family lawyers, we spend a lot of time dealing with, issues that come from the fallout of a separation. And for parties with children, parenting is a very big part of that conversation. For parents, a lot of times, nothing else matters really beyond the children. They might have millions in assets, but the most important conversation and issue they want to settle has to do with the children. For the most part, a lot of our conflicts generally involve scheduling and decision making and whatnot. But sometimes you have to have that difficult conversation about supervised parenting. Um, I mean, what is supervised parenting? Well, if you're asking what supervised parenting is, good for you, because then that means you don't have supervised parenting. Because if you did, then you know what it is. But really, it's just what it. Just take it from. I'm sure there's a more sophisticated definition, but for our purposes, like it really is what it says. Somebody supervising your parenting, and I think what I'm going to do is start from the forms that we've kind of seen supervised parenting take, right? So with me, I have seen clients that have had supervised parenting and have had it restricted just to the parenting center or the access centers as they're called. So Shia, what kind of form have you seen supervised parenting take?
So usually very similar at an access center. But one of my client, he chose the community service. So he was able to take the child around to different places and the supervisor will accompany them. Just so then, he has the option to take the child around, to take places and, it's not more restricted to one location.
Okay, I'm going to want to circle back to that because that's an interesting arrangement as well, both in terms of the options that it allows your client, but of course, there's always the question of cost. But Shireen, what form have you seen supervised parenting take with your clients?
So those are great. Those are more neutral third parties. More often, it's cases where they're relatives or a particular mutual person that is agreed upon that would supervise the visit. So it doesn't necessarily have to take place in such a very structured form. It could just be a grandparent or an aunt. Sorry.
Yeah, that's fantastic. Yes, because when people hear supervised parenting, it's great that you brought that option in because it's not so when we say what is supervised parenting, that's why I say again, it's just supervision. That's it. So it doesn't have to be a structured place. And we will talk about sort of the pros and cons of both, but it can be just a friend or family, as Shireen has said. So you could see that there's different formats that supervision can take. But in terms of when supervised parenting would be ordered, actually, I'm probably structuring that question wrong because there's times where the parties agree to it. Now, Shirin, have you had any experience where your clients have agreed to supervised parenting without a court order necessarily?
Yes, especially if there's been a long a time spent away from a child or a lack of foundation with the child, and they're just trying to reintegrate themselves, especially if they've been absent for many years. Sometimes it might just be from a substance abuse, but yes, I've seen that. It's very rare that parties automatically agree without some neutral assistance or some judicial input on it, but yes, it can happen, especially if it means that's the start of kind of reintroducing them to the relationship.
And so, Shia, you've had that happen as well, I believe, right?
Yes, yes. So basically, it's a situation where we're just negotiating with the opposing counsel, but parties agreed to have supervised parenting at this time. So right now they have like 6 visitation in place, and then after that we'll review the notes and go from there. But yeah, so in this case we don't have an order or anything. We agreed because there's a restraining order as well. So based on that, we're just slowly moving towards unsupervised parenting.
That's great to know because yes, a lot of times it is ordered, but it's great to know that parties can agree to it. And from my experience, and Sherry, you both have kind of covered this, right? Like there's usually factors that lead to it. So you don't just ask for supervised parenting because you want supervised parenting. It doesn't really work that way. There needs to be some basis for it, right? So Sherry mentioned if it's there's been time when you've been away from the child, and that way that period of time is kind of required to reintroduce yourself into the child's life. In Shantia's case, for example, where maybe one party is a little bit uncomfortable and the compromise is having this supervised parenting in a formal setting where you can get notes and things like that, and then you can review and pick it up from there. And also, if there's a restraining order, it's nice to have like that person facilitating things so that there's no breach of a court order. I've actually had scenarios, and this is one that I don't really like, but I've had scenarios where the other parent is the supervisor of the visit, right? Sharina, I want to pass this on to you because while I've had a number of experiences on this, I think you have one that's pretty interesting and why we're not necessarily a big fan of the other parent being the supervisor.
Yeah, so I'll actually talk about a scenario where it can be semi-appropriate and then when it's not really appropriate. So, and
Okay.
oftentimes when you have a newborn child, and there's both the level of new parents, right? So the requirement that, the child might have to stay with mom for a period of time, maybe she is breastfeeding, and sometimes parties can agree that, the other parent will supervise their time. They'll have in-home visits. Of course, there's parameters set in place that they're not just breathing down your neck. And these are more relatively for, I wouldn't say just for new parents, but for people who can get along and where it's appropriate. Where situations where I don't believe it's appropriate, I've had a situation where these parties clearly don't get along. There are some issues with, mom's family, and dad is only allowed to have parenting time at mom's house. And these are 8-hour stretches of time, which means that he's required to have food available. And it's an awkward environment for, 8-hour times, when you're looking at situations like that. And that's where the other party's specifically supervising their visits. So those are not appropriate, especially if there's an awkward or, not an appropriate dynamic between the parties at all. And for such long periods of time, I don't think it's appropriate unless there's, factors that warrant such a parenting arrangement in place. But again, the court's going to consider the relative uncomfortable behaviors that would encompass both from the child's perspective and from the parents. They're not going to want such a high level conflict individuals in each other's spaces. Having supervised visits would only lead to greater conflict, in my opinion. But yeah.
I mean, and your opinion is, I mean, has been fact in one of my cases where, mom and grandma were the supervisors, and it wasn't necessarily happening in the home. They were having these visits set up in parks at the mall and things like that. Let's just say there was a lot of entertainment created for the general public because they would, dad would try to take the child and at least, play a little bit, and they would videotape, they would make, denigrating comments and things like that. So obviously, that kind of parenting arrangement is horrible to say the least, but dad obviously just accepted that in the very short period of time because there was no other option. The only other option at that time was to have no parenting time at all. So usually, in addition to these factors that we've mentioned that would warrant supervision, there's also times where courts would on their own courts would order supervision if they think that a parent is behaving inappropriately. And I found in my experience, generally, it's usually when a person is behaving, I want to say very badly because I don't even, I don't, but I think I want to qualify that because it could be so subjective. I have had a client that was subjected to supervised parenting, where, in my opinion, it was shocking. There's times where you've seen parents that are completely off the rails, and somehow the courts are like, "Well, we'll put parameters in place and not necessarily supervision," right? But the point is, you are a role model to your children. And if you're behaving in a way that would um, affect them negatively, or that would be sending wrong lessons to them, an example would be if you're an overtly racist person, for example, and you're passing on those views to the child, then it might be appropriate in those circumstances to supervise. Now, that's something that would be as a last resort from the court's perspective. It's not something that they would like to order just routinely, but if there are grounds for it, remembering that the best interest of the child is the main factor that the courts have to consider. Don't be surprised if you do something that you think is not so bad, but if the courts feel like you're not acting in the children's best interest, then they would choose to have your parenting time supervised. Anyone have anything they want to add to that in terms of when supervised parenting is ordered, or?
Yeah, ultimately, just in short, if there's concerns or if the other party is raising valid concerns about the safety or the well-being of that child, whether it's through your own conduct of substance abuse, if there's violence that needs to take into consideration, if you're involving the children in inappropriate conflicts, or there's some element of parental alienation, those are where, circumstances that supervised visits are going to be looked at. And, those factors are, if there's something that ultimately affects the child in such a way that it's going to be some course of remedy that might be brought up if, conduct doesn't, correct itself.
Let's talk about the pros and cons of, oh, sorry, Sanshia, it looked like did you want to add something?
It's fine. She covered it. It's good.
Okay, all righty. So let's talk pros and cons here of having a community super. And I'm going to start with you, Sanshia. What do you see as the benefit of having, a structured, a more formal, supervised parenting arrangement? What are the pros from your perspective?
Sorry, from like the community, or sorry, are you asking?
Supervised versus like what do you prefer? Let me put it that. Let me put it in very basic terms. Do you
Yeah.
prefer to have an informal supervised parenting arrangement, or a community? Do I want to call it like, no, community is the wrong word. Have a more formal supervised parenting center doing the supervision.
So I think at the end of the day, it really depends. It's really depending on the type of situation each case presents. But ideally, I think that supervised parenting in the community is it's not too bad compared to having the child at either just at the parent's home or a place where it's more restricted, because this gives the parent to take the child around, right, to places that they both like to enjoy, and gives the child an opportunity to see what the parent is able to provide, to see that the parent is putting effort into making sure that the child is happy. And obviously the supervisor would be taking notes that could be later reviewed by either the judge or the lawyers to help their case, right? So at the end of the day, I think that supervised parenting at an access center is it's not bad, I would say. But at the same time, if it's in a situation where it's not it's not too of a high risk situation, then yeah, having a grandparent or an uncle or aunt be the supervisor, it's not bad either.
Okay, Shereen.
Yeah, I mean, I think it depends on who you ask too, right? So if you're asking a parent who has supervised visits, they would probably want a relative or some neutral third party. So it's not as formal, and it's not, I mean, there are situations where children are incredibly uncomfortable in those kinds of environments, right? But at the end of the day, safety is the utmost priority, right? The welfare and the safety of the child. So if you ask a parent, they would probably prefer to have, a less restrictive form of supervised visits. And especially when you look at, if it's a situation of a high conflict situation where one party is simply saying there are too many safety concerns, maybe a formal access center where you can have notes and access to those would be appropriate. But at the same time, there are pros, meaning that, you can get notes if you have a more formalized or structured environment that would assist your case. However, to some extent, it is manufactured, right? It is a small period of time. And with those kinds of visits, access centers only are open for a limited period of time, and there's an overflow. So if you're doing a community-based program, there's a lot of issues with respect to availability and the structure and the schedule there. So in my opinion, that would be a con, obviously, because you would have less time with a child as opposed to a relative who's able to make themselves available for long periods of stretches. So that's a con if you use a formal access center or some sort of community-based program. And then in terms of a positive, again, it depends on both the parties' comfort and the child's comfort. So overall, yeah, like it really depends on the circumstances, but as well, it's about, each family has a different approach, right? In my opinion, I do think that a less restrictive form of supervised visits is more appropriate, but it depends on how severe the concerns are that warranted such a supervised visit, supervised parenting order in the first place. Some of those things might not be appropriate if there's a history of, physical abuse for a child. And, a formal access center where that child can be safe is probably in the best interest of the child. And again, a bigger, greater pro than obviously a con in that circumstance.
Yeah, that's true. And of course, there's the issue of costs, which we should not forget, right? So most relatives and friends would do it for free. The supervised access centers, whether they're doing it in their facilities or if they're assisting you within the community, there's a cost to that. There's even, supervised access centers that would come supervise the visits in your home. Obviously, that costs a lot more, but those options are, of course, better than just being in their facilities and just I mean, I think I had a client once describe it as parenting jail, and I think it just makes it must feel like jail, every time you're in the same room, you could only play so many games and watch so much. Like I think it really should only be happening in the most exceptional of circumstances, and yeah,
And
so
it's as if you're,
yeah.
you're in, I mean, at the end of the day, it really again depends on the age of the child as well. But putting a child in that situation, you're also more like forcing the child to participate, talk to the parent. Whereas this is why I like the community, having the supervisor, attend with the parent and the child, because at least they're able to do other things. It's not like they're just really focusing on talking and getting along with each other, but whereas they're focusing on other things, and they're, it's like an easier way for them to sort of get back
And
to.
I agree with you 100% because even when you're forcing this interaction in a setting, whether it's even in the other parent's home or whatever, like well, maybe in the home that might be better even than in this access center, because then you have these notes that say, or one parent say, well, he doesn't, no, they don't really engage, and the children are not, they don't really care, and it's like, yeah, after a while, like if you're coming to the same room, the same place, like of course they're not going to care, they're not going to engage, right? So Jerry, you had said it earlier, it's a very like artificial like type of setup. And in the most
Especially,
exceptional and exceptional cases, it should not be ordered. And that's really, the idea behind most of the cases, right? So in terms of the case, it's seen as a very exceptional
remedy.
remedy. It's almost one step. It's pretty much one step removed from terminating parenting completely. So if you're being order to have supervised parenting, you should take it very seriously because the court is essentially sending you a signal saying they don't want you in this child's life anymore. And this is just kind of that bridge, right? There's generally it's accepted that a child having the benefit of both parents in their lives or in their best interest, it is in the child's best interest. But you may have conducted yourself, and I'm choosing my words very carefully because I do know that these situations arise in the context of a divorce or a separation. So people are not above lying, people are not above fabricating stuff. So when I say, take it very seriously, and it means that, you're one step removed from your child's life completely, I'm not necessarily laying blame here. I'm just explaining the optics of it, right? So, okay. Yeah, so let's see, where do we go? So, let's talk about, so we kind of talked about this because I wanted to touch on who could be, a supervisor, and we kind of did that. I think we said, it could be parents, friends, families, supervised access center and workers. Is there anyone we're missing? Oh, the other parent, for example, could be a supervisor. I think that pretty much covers it for the most part. Now, have you guys experienced any kind of conflict in choosing who the supervisor should be?
Absolutely.
Oh,
Um,
Sanchia, no, you haven't.
all the
Lucky you
time,
then.
right? I mean, if you are lucky enough to at least not agree to use a formal access center, then when you have to determine, who can that person be, there's always conflict. Either they don't trust that other person, it's usually from the other party. They don't trust the other party, or the party that they're proposing has their own issues, and they don't trust. I mean, it goes all beyond the level of trust. And then
Yeah.
it might be an individual that the other parent has actually never met. So it's hard, again, it goes down to the issue of trust, but it's hard for that person to justify why they're an appropriate person to supervise the visits. And I think a lot of the time is spent arguing about why they shouldn't, then why should they not? Because at the end of the day, if you don't have evidence to support that they're not an appropriate choice, then they're fair game.
I mean, I've had scenarios where it's a parent, for example, that they're proposing to be the supervisor, but this is a parent that, let's say it's the grandmother to the child, for example, and grandma was aware that, her son was being abusive during the relationship, or grandma is an enabler of this person's toxic substance abuse habits and things like that, then the courts would not really consider grandma as much as they, their hearts in the right place and they themselves are good people. They might not be appropriate supervisors because they're enabling the other person and may not be appropriate in those circumstances, right?
Yeah, especially if like high conflict and there's already a potential issue of involving the child in adult affairs, and maybe the family doesn't have a good rapport with the other parent. To propose anyone from that family could be also detrimental to the child because, it could be that they're having inappropriate conversations or hostilities or a very negative environment for that child to be subject to. So there's a lot of context that's required, but is a lot of circumstances too in terms of picking the appropriate person. There is no perfect person, realistically, but there are things that need to be kind of maneuvered to make sure that things go smoothly.
Yeah. I mean, interestingly, I've also had arguments over which supervised access centers to use. I can assure you, I'm usually not the one making those arguments because I do believe that a lot of them mean to do well and they do their best and whatnot. The fact that they may have reported less than favorably on one case doesn't necessarily mean that they're terrible in all cases. It is what it is. They would report what they observe. Okay, so let's kind of so if you found yourself in this unfortunate situation where your parenting time is supervised, the question that usually jumps out is how long would it last, right? Um, if it's a court order, it would be as long as that court, well, it could be any number of things. The court order in and of itself could include review provisions within itself. It could just be an order that's just left, and if there's a material change, then you come back and kind of look at that. But I just want to go through some case law that I was looking at recently, just in terms of just to give you guys an idea of what the law and how the law sees supervised parenting. So there's this case that's VSJ, and it says um, an order for supervised access requires exceptional circumstances as it's just one small step away from complete termination of the parent-child relationship. there's a presumption that regular access is in the best interest of the child. And supervised access is viewed, well, guys, don't try to piece this together. I'm just jumping around, just picking the relevant. I don't want anyone wondering what case. This is not how it was said in VSJ. No, I'm not reading it verbatim. I'm just picking the most relevant part for talking about how the courts view this. So, the court in this case said supervised access is seldom viewed as an indefinite order or long-term solution. That's a common theme in all of case law. It's not, it's supposed to be temporary. And say the purpose of supervised access, far from being a permanent feature is in a child's life, is to provide a temporary and time-limited measure designed to resolve a parental impasse over access. And in this case, it says, although it can continue on more than just a short-term basis, it's never a permanent solution to the problems. In a different case called Pereira, they were dealing with institutional, which is what we were referring to as the more formal supervised access centers. And it says it's something the court in this case felt that it's something that should be avoided if possible. It says the visits are anything but normalized access. However much the center may attempt to provide a relaxed atmosphere, it is access in an institutional setting, which necessarily limits the parameters of visits. The visiting parent can go outside, he or she can take the child shopping or go to a park or a movie, but it's not necessarily, it's always limited to the resource of the center. And most times they have no more than a few hours a week. And in this case, it also confirmed that it should only be ordered where absolutely necessary for justice to err on the side of caution. And so it should, and then they set circumstances, including, serious safety concerns and things like that. So these are all things that we've said, and I could go, on and on. In the Martin, it said supervised access is intended to assist in overcoming parent issues and reestablishing a parent-child relationship. It's normally the subject of a temporary order, and it is not a proper arrangement on a permanent basis as it is conducted in an artificial environment. And in reality, it teaches children the wrong lessons regarding a parent's role. I really like that the judge added that, because can you imagine having to see your child in this kind of institutional setting? It really does send the wrong message about you as a parent. And so the good news is and the reason why I went over those cases using, precisely the words by judges in multiple cases is that take heart in the fact that the courts recognize that it is something that's temporary. They're not trying to forever have you supervised. So at least take comfort in that. When you're going through when you're going through the process, it may feel like it's lasting forever, but it will change. The courts are very live to the fact that it's not the best arrangement, but if they're just trying to err on the side of caution, and that's why they're doing that. So does anyone have any direct answer into how long it would last?
Each matter is different. No, I don't have a direct or specific answer. It takes as long as it takes. And that meaning
I like that. It takes as long as it takes.
Yeah, it takes as long as it takes. It could be that, if you're a new parent, you just need some time to justify that you have the ability to parent. Supervised visits could be limited. They could be structured. I always recommend adding a structure period, a review period, because it makes the most sense. If there's concerns, that parenting time, if there's safety concerns, whether or not they are true and parenting time or supervised visits get ordered, then it's in that situation that you want to make sure that you have evidence to support that you're complying. If there's an issue of substance abuse, have negative drug tests beforehand so that you're showing that you're trying. If you're an explosive personality and, maybe that's why parenting time was ordered to be supervised, then, do some counseling sessions, make it, it takes as long as it takes. But there needs to be a mechanism. If there are reasons for ordering supervised visits exist still at the time that you're reviewing those provisions, it may not be appropriate to lift that supervision period. So in that sense, just making sure that the very reasons that were the concerns are taken care of at least, or addressed along the way, so that they, when we're doing a full review, it makes sense to lift a restriction.
Yeah. So Share, anything to add to what Shirin's told us?
No, I agree with her. It really depends on, on the case and the situation. So yeah, it will take as long as it takes, but it really, yeah, like she said, just make sure that you're following the order if you have to, if there is an order in place. If you're negotiating, then of course, just, if there, like I said, if there's a restraining order, take an anger management class, whatever you have to, just to make sure that, you get there, you have the unsupervised parenting time, when you're ready, but you'll get there.
And what I have to remind a lot of people too is if you're in this scenario and you feel like you're being unjustly dealt with and all of that, remember that the other side knows your triggers. The other side knows your triggers. They are going to annoy you. If the situation is so explosive to the point where you found yourself, in circumstances where there's now a restraining order against you, for example, or you've behaved in a way that's so inappropriate that the court thinks your parenting time needs to be restricted, we know we're asking you for a miracle here, but it's not so much a legal issue as it is a you issue. And by you I mean the person with supervised parenting being ordered against them. So let me give an example. Let's say you were wrongly accused of, I don't even know what could you, there's just so many things you could do to get supervised. But let's say you're being wrongly accused of being a racist or being homophobic and teaching the children hate. And let's say that's all being taken out of context. Um, and the other side has successfully framed these things in such a way that, the courts can see it harming the children. Because remember, your views, much as it might be distasteful to the court, is not reason to order supervision. The only reason why they would order supervision under these circumstances is because it's hurting the children. So on the one hand, yes, you have a right to freedom of speech, you have a right to do whatever you like, but if you do that, it doesn't change that. And then the other side is going to continue saying that you're affecting the children's best interest. So, yes, we expect a miracle from you. We expect a complete, 180. If you had certain views, keep them to yourself. Do you want to have your freedom of expression, or do you want freedom to parent your children, in your own space, not in a, supervised setting, right? So that's kind of, so I know it's difficult. And would the other side judge every, move you make and every word that comes out of your mouth, for example, if the allegations, for example, is that you're threatening and things like that, yeah, is it possible that even when you say hello, the other side would accuse you of threatening them? Absolutely. So, as your lawyers, don't put us in a situation where we can't do anything for you. Don't say hello to the other side. Like, really, don't. Don't step up to their doorstep when you drop off, like, in whatever scenarios. Like, I've seen people in supervised settings where they would have, they wouldn't even keep to time, or they would go through you parking in wrong places. Like, just it's the littlest, dumbest thing. And if you're already here, you know that the other side is already taking everything out of context. Or if you're about to get your parenting time supervised, you probably feel like everything's being taken out of context. So we're asking for a miracle from you because you need to give us the right facts to be able to make these legal arguments, because it's extremely fact based, and just help us work that miracle. I don't know if I've expressed this strongly enough. Somebody else, please add something to that.
Yeah, no, it makes sense. Like, let us help you, help us help you. Don't make situations worse, especially if you're already subject to an order and you're sending threatening messages to the other side. And I've seen it time and time again. You would think something of that magnitude, like a supervised visit and restraining order, would restrain you from doing those things. But you have to make sure that you're on, like, there's only so much that a lawyer can do with your own personal behavior and conduct. So it's up to you to put your best foot forward to make sure that you are as agreeable, and making sure that you're not putting your foot in your own mouth when you're, making these. I've seen such atrocious messages to the other parent when they're subject to an order, or their frustration, or them stalking them outside of their
Sure, not
home.
not even sending a message at all, because when you say a atrocious message, someone's going to pick that up and say, but I sent a very nice message. But what if your terms of your order says do not communicate with the person? So it doesn't mean
Yes,
you,
if
it's
it's,
not okay for you to even say good morning. If the terms
yeah.
of your order says do not communicate, don't.
Not communicate.
Yeah, a lot of the times, especially when dealing with like a separation and people haven't really accepted those terms, and maybe fine, maybe not an atrocious message, but a message that could be manipulated to look like you're just not accepting of the separation doesn't also look good. So
Yeah.
there's that circumstance. There's also the circumstance of physical distance. Like you said, you shouldn't have to be, going straight to the door, especially in a high conflict situation. There should be an ability for someone to intercept. There's also, I mean, we didn't talk about this, but there's also, and I mean, it's not necessarily, well, it can't be with supervised visits. It's a less restrictive form of supervised visits where you just supervise the exchanges because of a high
Mm,
conflict situation.
mhm.
So there's circumstances where you just don't want to look like you're enticing conflict and you're making things worse. If there's a matter of, contention between the parties, make it that you're the one proposing family counseling, a parenting coordinator. You're doing these, third party therapeutic interventions to support the separation. And if the child needs therapy and, maybe you're not also on board, that's a concern, right? Sometimes it can, I mean, sometimes not appropriate, but if it's recommended by the doctor or a professional working with your child, be open and receptive to those kinds of recommendations. It makes it look like you're an involved parent, and that overall the safety and the well-being of the child is cared for. Clearly something that is in the forefront of your consideration in terms of parenting. So all of those things help. Just don't make it worse is ultimately what I'm trying to say in all of that, is just don't make it worse, really.
Yeah, some people put so much faith in, they think it's the lawyer. And this is one scenario where it's not about the law. The law says the best interest of the child. If we cannot position your actions in a way that aids promotes the child's mental, physical, and emotional well-being, then there's really nothing we can do for you. Like there really isn't. So it's not about legal maneuver, and sometimes people are like, yes, we can get in front of a judge and we can pick apart that message you sent, and it's not so atrocious and it's not so this and that. But the judges are past that. They're looking at what's in the child's best interest. So, you know, just be the best version of yourself, generally, because that's really what we should all strive to be anyway. But we know that when you're going through a separation, it's a very trying and tempting time. So just
Yeah,
be
we're
careful.
not judging. We just want to support you in being on that journey. But it also, you shouldn't make it more difficult on yourself. And it's often that people will self-sabotage and self-destruct, especially with an order they're not happy with. It's important to kind of get it, a global perspective. I guess I mean, at the end of the day, these are your children or your child. So it's a difficult to not make emotional decisions. But you need to kind of remove yourself, look at it as, okay, this is the situation, this is what I think it's going to take for you to get here, these are the steps that you can take to get there. And I think that's also what we're going to talk about now is, what can we do to avoid supervised visits as a whole.
Sharon, I want to second what you said about we're not judging you. Honestly, no judgment, because for some, we get it. We get it. We know that the other side is possibly lying against you. And because they've now lied, it's now actually triggering the reaction that they actually said you had. So we know that. We know that, you really mean for the best interests of your child, and things are being taken out of context. We're not here to judge. And then we also know, quite frankly, that there's times where you've made mistakes. We're all human beings. We all make mistakes. And some of the issues that I see in family courts that are being blown out of proportion, would no one would even talk about it if the parties were still together, right? as parents, we make mistakes, we fix it, we get better. So look at it as that's where you are, right? It's unfortunate that now you literally have an adversary on the other side. And so please, I just wanted to second what Shireen said about judgment. We are not here to judge you. That is not our role. We are on your side. And all of this is just to make sure that we help you lift that supervision order, which Shireen wanted us to jump into. So yeah, what steps can we take to lift the supervision order? I'm going to say the most obvious one. Just don't do anything worse than you've already done. So Shia, did you want to add something there?
Yeah, I was gonna just say that. Just don't do everything that we almost pretty much told you so far not to do. But yeah, generally, if you know, just complete the, you know, if there is already a supervised parenting going on, complete the you know, requested supervision that's in place. If there's 6 or 5, 8 sessions, whatever the case is, complete it. And then at that point, we'll review the notes, and then we'll go from there, hopefully to unsupervised parenting. And then you know, if there's other requirements by court order, like, you know, taking anger management classes or therapy, whatever the situation is, complete those, because obviously you want to support yourself and you know, get the judgment that you really want, where you have unsupervised parenting with your kids. But those are, you know, some of the steps that you should start taking from day one, as soon as you have supervised order, to be able to get that eventually.
Okay, thanks.
Yeah. So, I mean, to speak to your point about before we even get to that point, like how to even avoid getting the notion where supervised parenting is even ordered, I want to look at the specific issue. So let's say the issue is that there's a substance abuse issue at play, and the other party has concerns about your parenting time. It's important to have discussions about the use of substance abuse, and let's say it's a pure fabrication, then it's warranted. Get a drug test. You know, show that the other side is inflating and manufacturing issues that don't exist. You know, and sometimes when you're dealing with contentious matters, it could be this, that, or the other. You know, if it's not substance abuse, it's physical abuse. These things need to be looked at. So if there's a matter of physical abuse and the other party is, you know, restricting your parenting time, there needs to be some sort of evidence that flows from that too, right? So if there's CAS involved, which is the Children's Aid Society involved, if there's a physical, maybe in the past, or whatever the circumstances, and maybe there is one ongoing, follow the recommendations of the CAS worker. If it's that, you know, they haven't ordered supervised visits. So things to avoid getting an order for supervised visits. So looking at the specific conduct that's warranted, and then how to make sure that you're correcting it. If it's a matter of supervised visits because the child is new, create a download an app for new parents that talks about the schedule for, you know, feeding, for nap time, for whatever the circumstance, so you're both on the same page and there's some stability for both of you. So every concern that the other parent can have can essentially be taken care of before there's even an appropriateness for supervised visits. Because again, like we talked about, it is the remedy of last resort. There are ways to get restrictions in place that don't involve supervised visits. So yeah, just being a little more factual, I assume, and proactive on the issues that are being raised that warrant.
I laugh because you mentioned apps. And I was like, wow, I thought this just ages me because I'm like, yeah, read a book on parenting. She's like, no, download an app.
Do a
I'm like, oh
parenting
my
class.
God,
Yeah, a lot of people do parenting classes too,
much
and that's often
easier.
recommended. Actually, yeah, a parenting class is also recommended often too by the court. There's about 3 or 4, you know, John Howard Society programs that, you know, if it's this, if the party's saying, I don't have, I have concerns about you being effectively able to care for the child. It's as simple as, I mean, you don't have to necessarily prove to the other side that you can, you know, you are just as much as a parent as they are. So a lot of the times the concern is, well, why do I have to show XYZ? At the end of the day, it's also going to be a benefit to you. These programs, as well as even for separated parents, they make programs so that you can effectively co-parent with the other party. There's so many creative solutions to get around getting down that road to supervised visits that you can avoid completely, in my opinion.
If you're there, like so Cher aptly said, do not do or do not do everything we've said. Well, listen to it and do the things that we think would benefit you, and don't do the things we've asked you to avoid. And look at your order very closely and follow whatever it says. So that's and I think Sunshare kind of covered that, so I wouldn't go back there. But don't attempt to lift a supervision order if nothing's changed. It's just, people see this as a right, which to be fair, I can agree that it's your right to, have that unsupervised parenting time with your child. But remember that in all while you're exercising your rights, it has to be in the child's best interest. So look closely at why the other side it has, why you guys, if it's not a court order and you agree to it, what were the circumstances leading up to that? And if they know, make sure that you do everything, as Sharina said, within your power to avoid it. But if you couldn't avoid it and now supervision has been ordered, well, then show that there's been a change and you're not that same person that you used to be. Substance abuse is one that's pretty difficult. For your own health, we would like you to stop abusing substances completely, but sometimes it can't be done. So, can we find ways to show that during your parenting time, you're not under the influence of anything, right? There's tests that can be taken at home. I can't remember what the name I forget the name. There's the one we use for
The breathalyzer.
alcohol. Is it the Sober Link one? Yes, that
The super
you
link.
could
You
use
could
it.
also have your own personal breathalyzer. I've had a file where, before their parenting time, they will just come while they're doing exchanges. He'll take a breathalyzer, his personal one he bought on Amazon. I think they're like $60. And he will
Okay.
satisfy that he's fine to drive. And parenting time will continue and go from there. If he's not, he
Yeah.
doesn't have parenting time. And that's fair. So, I mean, there's circumstances around, at least easier to satisfy with alcohol, in my opinion. But
Yes. So yeah, so if you can show that, and even if with during the period of supervision, if it's in a formal supervised setting, they would make notes of please don't accidentally show up high or whatever. It would make it into the notes, and just one incident of you being high would negate all of the other incidents when you weren't high. Because again, remember, we're looking at the best interest of the child. So get high or don't get high on your own time. But if supervision is time to see your child is coming up, if you're thinking about the best interest of your child, then you want to make sure that you are sober and as present as possible throughout those visits. Court order, follow to the letter everything that's said in the court orders. They're not suggestions. And if a court's already ordered supervised parenting, then you're really at the borderline with them. So just missing one thing or the other is not going to look good. And so just check all the boxes, follow everything to the T, and you know what? You might come out with this, come out of this stronger and even a better parent. That would be best case scenario. But that's fine. That's, that's your journey. Our role is to make sure that, we get you back having a more normal parenting time with your child and enjoying that relationship. And we all know that the entire, family law bar, we recognize that your children having a relationship with you is in their best interest. So we know that. Just help us help you have a normalized relationship with your children. Is there anything else we can add to this topic, or have we bit it up long enough?
no, I mean, a lot of this was done on the basis of, you being the parent who has supervised visits. But if you're a parent who's seeking supervised visits, this might also be helpful too. So, I mean, at the end of all this, there's a lot that goes into it. It's when it's appropriate, when it's ordered, how to lift it, and how to avoid it. But ultimately, just follow, if you do have an order, follow the steps of those orders so that, you're not making a situation worse. And
No, so
definitely
now
speak
you
like
started a new topic that I actually want to. Now you're
dive
going
in.
to put us here for a few more minutes because
Okay.
we have to really, you're right. We've looked at this from the perspective of the person being supervised. And yes, if you're the one that needs to get that supervision order, you're probably listening like, what is here for me? And yes, Sheree, thanks for reeling this back in. If you think, so now we're going to talk about it from your perspective. If you think that the other side is not acting in your child's best interest, yes, absolutely. Do let your lawyers know. It's absolutely important that they get supervised, that they get their parenting supervised if that's, what it's going to take. And it could be for any number of reasons, right? Safety concerns. Are you concerned that they're going to abscond with the child if you allow them have that just parenting time on their own? Obviously, many people think this without any basis, but if you have grounds for thinking this, don't hesitate to share it, right? If you have concerns around, I don't know, sexual abuse, even physical abuse, right? We've had clients that have come back to us and or when the children return, they have concerns about how the children look, but most especially emotional abuse, because sometimes that's the hardest to see, right? You know your child, and if they're not, their behaviors are different after parenting with the other parent, parenting time with the other parent, that might be worth having a conversation, right?
Yeah, absolutely. I think a lot of the times it's difficult to tell, especially with younger children. So sometimes parents who, especially new parents, kind of, for lack of better words, freak out if, the child comes back and their behavior is just way off. And the reality is sometimes that happens when, a child is getting used to two different environments. So a lot of it is might be, just immediate because of the schedule, and the child getting used to it. Sometimes, when people come to me with concerns about, parenting, they're not enough to warrant supervised visits. And I'm honest about that. Sometimes there are other ways to put parameters in place that don't go to supervised visits because I don't think they'll be successful on what, they brought to me. But it's important to know that if there is a serious concern like the ones we've raised, it's important to have those conversations. If you have a lawyer, then a plan in place about how to best protect your child or children from the other parent. And at the end of the day, that's what matters, right? The best interest of that child.
Yeah. So should you have anything from the perspective of the parent that's seeking supervision?
I think you guys covered it. I can't think of anything that I can add right now.
Yeah, so I mean, obviously from if you're the parent that's seeking sort of that supervised parenting, you've everything we've said, you could see that your concerns will be taken seriously, can be taken seriously. And you also would have heard that if the other party doesn't change, then they will continue to have their parenting time supervised. So if you're that parent that needs that protection for the children that's moving to get that in place, hopefully that gives you some comfort to know that the legal system does have that protection in place for the children. All right, so we will end it here for today, and yeah, until next time, bye for now.
Bye.
Bye.